Natural law school. Roman period to modern period and Indian context. Introduction. The natural law school is one of the oldest and most influential schools of jurisprudence. It is also known as the philosophical school or moral school of jurisprudence. The central idea of this school is that there exists a higher law based on reason, morality, or divine will, which is superior to man-made law. According to natural law thinkers, if a human law conflicts with natural law, it loses its validity. Meaning of natural law. The term natural law, Latin, lex naturalis, refers to a law that is inherent in human nature, discoverable through human reason, and common to all societies. It is not created by human authority but is universal, eternal, and unchangeable. Key idea. Natural law is the law established by nature, common to all men, and superior to positive law. 3. Characteristics of natural law. The natural law school lays down certain basic features that distinguish natural law from man-made law. These characteristics explain the nature, scope, and importance of natural law. Natural law is believed to be universal, moral, and based on reason, and it acts as a standard to judge the validity of positive law. The main characteristics of natural law are explained below. Universal, applicable to all people, everywhere, at all times. Eternal, exists independent of time and government. Rational, discovered through human reason. Superior to positive law, man-made laws must conform to it. Moral foundation, based on justice, fairness, and morality. Historical development of natural law. The natural law theory has developed gradually over time and has taken different forms in different periods of history. Its meaning and basis changed according to social, political, and philosophical conditions. From the Greek and Roman period, through the medieval religious period, to the modern rational and human rights-based approach, natural law has continuously evolved. The historical development of natural law helps us understand how it shaped legal thinking and justice across ages. Ancient period, Greek and Roman period. The ancient period marks the beginning of the natural law theory. During this period, natural law was closely connected with reason, nature, and universal justice. Greek and Roman philosophers believed that there exists a law higher than man-made law, which is based on rational thinking and applies to all people. In the Greek period, thinkers like Socrates, Plato, and Aristotle emphasized moral reasoning and justice as the foundation of law. In the Roman period, jurists developed the concepts of jus naturae, law of nature, and jus gentium, law of nations, giving natural law a practical legal form. This period laid the foundation of natural law jurisprudence. A. Greek period. The foundation of natural law was laid by Greek philosophers. The Greek period laid the foundation of the natural law theory. Greek philosophers believed that there exists a higher law based on reason and justice, which is superior to man-made law. Socrates believed in universal moral principles and stated that law must be based on reason and conscience. Plato spoke of an ideal state governed by justice, where law should aim at the common good. Aristotle distinguished between natural law and positive law and said that natural law is universal and immutable. Thus, Greek thinkers treated natural law as a rational and moral standard to judge human laws. Socrates, 469 to 399 B. He believed in universal moral principles and stated that there is a law higher than human law, based on reason. Socrates was one of the earliest philosophers to support the idea of natural law. He believed that there are universal moral principles which are higher than man-made laws. According to him, law must be based on reason, justice, and conscience. He taught that human laws are valid only when they conform to moral truth. Thus, Socrates laid the foundation of natural law by linking law with morality and reason. Plato, 427 to 347 B. He advocated an ideal state governed by justice and reason, where law should aim at the common good. Plato was an important Greek philosopher who contributed to the natural law theory. He believed that law should be based on reason and justice. In his idea of an ideal state, law is made to achieve the common good of society. Plato emphasized that rulers should be guided by wisdom and moral values, not personal interest. According to him, a law that is unjust cannot be considered true law. Aristotle, 384 to 322 b. He distinguished between natural law and positive law, stating that natural law is universal and immutable. Aristotle gave a clear explanation of natural law. He distinguished between natural law and positive, man-made, law. According to him, natural law is based on reason and nature and is universal, eternal, and unchangeable. Positive law, on the other hand, varies from place to place. Aristotle believed that human laws should be made in accordance with natural justice. His views strongly influenced the development of natural law theory. B. Roman period. The Romans developed the concepts of jus naturale, natural law, and jus gentium, law of nations. The Roman period played an important role in the development of the natural law theory. Roman jurists gave a more practical and legal form to the ideas of natural law. They developed concepts like jus naturale, law of nature, and jus gentium, law of nations, which were based on reason, justice, and equality. Natural law during this period was considered universal and binding on all people, laying a strong foundation for modern legal systems. Cicero, 106 to 43 b. He defined natural law as right reason in agreement with nature, universal and everlasting. He believed that natural law binds all nations. Cicero was one of the greatest Roman philosophers and jurists who strongly supported the natural law theory. He defined natural law as right reason in agreement with nature, which is universal, eternal, and unchangeable. According to him, natural law applies to all people and all nations and is superior to man-made law. He believed that unjust laws are not true laws. Cicero's ideas greatly influenced Roman law and later natural law thinkers. Stoic philosophers. They believed in universal brotherhood and law as part of divine reason, influencing Roman legal thought. Augustine, 354 to 430 a. He believed that eternal law is God's law, and human law must conform to it. Augustine was an important thinker of the medieval, theological, period who linked natural law with divine law. He believed that eternal law is the law of God, and all human laws must conform to it. According to him, a law which is unjust or against God's will cannot be considered a true law. Augustine emphasized that obedience to law is meaningful only when it is morally and divinely just. Augustine, 354 to 430 a. He believed that eternal law is God's law, and human law must conform to it. Augustine was an important thinker of the medieval, theological, period who linked natural law with divine law. He believed that eternal law is the law of God, and all human laws must conform to it. According to him, a law which is unjust or against God's will cannot be considered a true law. Augustine emphasized that obedience to law is meaningful only when it is morally and divinely just. Thomas Aquinas, 1225 to 1274 a. He gave the most systematic theory of natural law and classified law into eternal law, divine law, natural law, human law. According to Aquinas, human law is valid only if it conforms to natural law. Thomas Aquinas gave the most systematic and influential theory of natural law during the medieval period. He believed that law is an ordinance of reason made for the common good. Aquinas classified law into four types: eternal law, God's plan, divine law, revealed in scriptures, natural law, part of eternal law known by human reason, and human law, laws made by humans. According to him, human laws are valid only if they conform to natural law, otherwise, they are unjust and need not be obeyed. Renaissance and Enlightenment period, 15th to 18th century. natural law became secular and rational, moving away from religion. The Renaissance and Enlightenment period marked a major change in the natural law theory. During this time, natural law shifted from a religious and theological basis to a rational and secular foundation. Thinkers emphasized human reason, individual rights, and freedom rather than divine authority. Natural law was now seen as based on human nature and rational thinking, laying the foundation for modern ideas of natural rights, social contract, and constitutional government. Hugo Grotius, 1583–1645. Hugo Grotius stated that natural law would exist even without God. It is based on right reason. Hugo Grotius is known as the father of modern natural law. He separated natural law from religion and said that natural law would exist even if God did not exist. According to him, natural law is based on right reason and is binding on all people. Grotius believed that natural law protects basic human rights and governs relations between individuals and states. His ideas greatly influenced international law, constitutional law, and modern legal systems. Thomas Hobbes, 1588–1679. Believed natural law led people to form a social contract to escape chaos. Thomas Hobbes was an important thinker of the Renaissance and Enlightenment period. He believed that in the state of nature, life was nasty, brutish, and short. To escape this condition, people agreed to form a social contract. According to Hobbes, natural law guided people to seek peace and security by surrendering some freedoms to a sovereign authority. Although his ideas later influenced legal positivism, his theory was still based on natural law reasoning. John Locke, 1632–1704. Propounded natural rights, life, liberty, and property. Government exists to protect these rights. John Locke was a major thinker of the natural law school during the Enlightenment period. He believed that all individuals are born with natural rights, especially the rights to life, liberty, and property. According to Locke, governments are formed through a social contract to protect these rights. If the government fails to protect natural rights, people have the right to resist or overthrow it. Locke's ideas greatly influenced modern democracy, constitutionalism, and fundamental rights. Jean-Jacques Rousseau, 1712–1778. Advocated popular sovereignty and the general will, giving moral basis to law. Jean-Jacques Rousseau was an important thinker of the Enlightenment period who contributed to the natural law theory. He believed that humans are naturally free and equal, but society often corrupts this freedom. Rousseau explained that through a social contract, individuals give up some freedom to form a society governed by the general will. Law, according to him, should express the general will and aim at common good and equality. His ideas influenced democracy, popular sovereignty, and constitutional law. Modern period, 19th to 20th century. Natural law declined due to the rise of legal positivism, Bentham, Austin. However, it revived after World War II due to inhuman laws under authoritarian regimes. During the modern period, the influence of natural law declined in the 19th century due to the rise of legal positivism, led by thinkers like Bentham and Austin, who emphasized state-made law and ignored morality. Law was studied as it is, not as it ought to be. However, in the 20th century, natural law was revived, especially after the World Wars, when strict positivism failed to prevent inhuman and unjust laws. Thinkers like Lon. Fuller, Gustav Radbruch, and John Finnis re-emphasized the importance of justice, morality, and human rights in law. Thus, natural law regained importance in modern legal thinking. Lon. Fuller propounded the theory of inner morality of law, emphasizing procedural fairness. Lon. Fuller was an important jurist of the modern period who played a key role in the revival of natural law in the 20th century. He is best known for his theory of the inner morality of law. According to Fuller, a law must satisfy certain moral principles in its procedure to be valid. He laid down 8 principles of legality, such as clarity, consistency, generality, prospectivity, and fairness. If these principles are not followed, the system cannot be called true law. Fuller thus connected law with morality, especially procedural morality, and showed that law without moral content cannot function properly. John Finnis. In Natural Law and Natural Rights, he identified basic human goods necessary for human flourishing. John Finnis is a modern jurist who gave a new and systematic form to the natural law theory in the 20th century. In his famous book Natural Law and Natural Rights, he explained that law should promote certain basic human goods necessary for a good life. According to Finnis, these basic goods include life, knowledge, play, aesthetic experience, friendship, practical reason, and religion. He believed that law and morality are closely connected and that a legal system must support these values to be just. Finnis thus made natural law practical, rational, and relevant to modern society. Natural law in Indian context. Natural law has a strong influence on the Indian legal system, both in ancient times and in modern constitutional law. Natural law has had a deep influence on Indian legal thought, both in ancient times and in the modern constitutional system. In ancient India, the concept of dharma represented law based on morality, justice, and righteousness. Texts like the Dharmashastras taught that law must conform to ethical values, similar to natural law principles. Buddhist and Jain philosophies also emphasized justice, compassion, equality, and moral order. In the modern Indian context, the Indian constitution strongly reflects natural law ideas. The preamble guarantees justice, liberty, equality, and fraternity. Fundamental rights are based on natural and inherent human rights, especially Article 21, right to life, which has been interpreted to include dignity, fairness, and reasonableness. Through judicial review, Indian courts strike down unjust laws, showing that law must conform to justice and morality, not merely state authority. A. Ancient Indian thought. In ancient India, law was based on dharma, which meant moral duty, justice, and righteousness. Texts like the Dharmashastras and Mrjsbhatti taught that law must be in accordance with morality and ethical values, similar to natural law principles. B. Buddhist and Jain philosophy. Buddhism and Jainism emphasized justice, equality, non-violence, and compassion. These ideas support the belief that law should protect human dignity and moral order, which are key ideas of natural law. C. Modern Indian Constitution. The Indian Constitution reflects natural law ideals. Preamble guarantees justice, liberty, equality, and fraternity. Fundamental rights, Part 3, are based on natural and inherent rights. Directive principles, Part 4, promote social justice and moral duties of the state. D. Role of judiciary. Indian courts often apply natural law principles while interpreting laws. In Maneka Gandhi v. Union of India, 1978, the Supreme Court held that law must be just, fair, and reasonable. In Kesavananda Bharati v. State of Kerala, 1973, the Basic Structure Doctrine protected fundamental moral values of the Constitution. Criticism of natural law theory. Despite its importance, the natural law theory has been criticized on several grounds. Vague and abstract, natural law is often described in broad terms like reason and nature, which are difficult to clearly define. Subjective in nature, different thinkers give different meanings to natural law, making it uncertain and inconsistent. Unclear foundation. Natural law is sometimes based on religion and sometimes on reason, leading to confusion about its true basis. Conflict with legal positivism. Positivists argue that the validity of law depends on state authority, not morality. Practical difficulty. In a diverse society, it is difficult to identify one universal moral law applicable to all. Importance and relevance today. Foundation of human rights. Promotes justice and rule of law. Acts as a check on arbitrary power. Influences constitutional and international law, UDHR, UN Charter. The natural law theory continues to be highly important in the modern legal world. It forms the foundation of human rights, emphasizing values like justice, equality, liberty, and human dignity. Natural law acts as a moral standard to judge man-made laws and prevents arbitrary use of power by the state. It strongly influences constitutional law, judicial interpretation, and international law, such as the Universal Declaration of Human Rights, 1948. Courts often rely on principles of fairness, reasonableness, and natural justice, which are rooted in natural law. Thus, even today, natural law remains relevant as it ensures that law serves justice and humanity, not just authority. Seven. Conclusion. Natural law has evolved from divine law to rational and human-centered principles. Despite criticism, it continues to guide constitutional interpretation, human rights, and justice, especially in India. It reminds us that law without morality cannot ensure true justice. The natural law school has evolved from divine and moral ideas in ancient times to rational and human-centered principles in the modern period. Despite criticism, it continues to play an important role in promoting justice, morality, human rights, and the rule of law. In the Indian context, natural law is clearly reflected in the constitution and judicial decisions. Thus, natural law remains a guiding force, reminding us that law without justice and morality cannot be true law. Natural law equals justice plus reason plus morality above state law.